The Honourable Phil Goff.
Mr Chairman, the amendments to the Domestic Violence Act of 1995 are generally appropriate, in my view, looking at the evidence. But I want to talk about the general point of how the government has gone about putting this part together. Because when I read the bill, I see that there is no less than 20 pages of deletions in the... No fewer, if you like. No fewer. There's probably more, actually. More than 20 pages of deletions in the bill that the Minister brought to the House. Now, any bill that a Minister brings where one part is almost entirely deleted and has to be replaced is a suggestion, Minister, that this was ill-drafted, ill-prepared and ill-researched. And there's no better authority for those accusations than your own regulatory impact statement that you delivered late to the House after, in fact, the first reading of the bill had taken place. And that said that although there had been some research done, the research was limited. You looked at other countries, the United Kingdom and Australia, despite the differences in the system. The regulatory impact statement then said that there was insufficient historical, fiscal and statistical data to accurately predict the average costs of performing some of the tasks associated with the processes. There was insufficient time for piloting, proposed processes or for undertaking an historical file review to obtain further data. Because of the time frame, there was limited opportunity to discuss the final proposals with stakeholders. Now, all of those criticisms, Minister, are from your own Ministry of Justice. And when you bring a bill to this House where Part 2 of the bill is almost entirely deleted and rewritten, that suggests poor preparation on your part, and it suggests a bill that is half-baked in this part and, unfortunately, even more so in some of the other parts of the bill that we most object to. Mr Chairman, the other worry that I have is that the previous Minister actually set up an expert reference group to give advice on this. Now, they were people who on average had done 20 to 30 years either as family court lawyers or as psychologists. These were people that were enormously experienced in this area. And the Minister's report, or from her ministry, says that they followed the advice of the expert reference group. Well, the expert reference group was highly offended at that statement in the report, and they said that in key areas of that report, in fact, Minister, you entirely ignored their advice. And this is what their submission says about domestic violence, the very part of the bill that we're looking at. It said that the hidden dynamics of domestic violence and abuse will mean that many women will be at risk from a new family justice system, that's the system the Minister is introducing in this bill, which creates barriers of cost, rights to representation and legal aid, and early intervention in cases by judges. Barriers in terms of costs, barriers in terms of rights of representation, barriers in terms of more restricted legal aid, barriers in terms of the judges being able to intervene before the dispute becomes nastier and more difficult to resolve. It's a two-tier justice system created by this bill which significantly increases the risk for victims of violence. So, Minister, this part of the bill that purports actually to improve the situation for victims of domestic violence, according to the experts appointed by your predecessor, they say whatever happens in terms of the technical changes in this part of the bill, the overall effect of the bill is to worsen the impact of violence, to increase the risk to victims. And it is almost without precedent that a minister sets up an expert advisory group, that group is ignored, and then that group says the bill will do exactly the opposite of what the minister comes to the House and purports that it will do. So we are very concerned Mr Chairman, about whether the overall effect of the bill on domestic violence will be helpful. Now, I want to look at the specific provisions of this part, Mr Chairman. Mr Chairman.
Honourable Phil Goff.
The current legislation in terms of domestic violence allows for the issue of protection orders, and the respondent under those orders is generally required to attend a domestic violence program. The difficulty with the status quo, and this is where I do agree with the detail of this part of the bill, the programs are heavily prescribed in regulation, and the attendance by the other party, not the violent party but the respondent, is also very low, which suggests that the nature of the programs that are being run for both the perpetrators and the victims of domestic violence need to change. Many respondents don't complete the program, and the answer to that is to, in this part of the bill including, is simply to increase the penalty that applies. It goes, I think, from 2 years of imprisonment up to 3, if I recall that rightly. Well, I don't think imprisonment because you fail to attend a program is actually the effective answer, and the more effective answer in this part of the bill will be if the programs are designed to actually meet the real needs both of the respondents and of the perpetrators of the bill. So I think it's a good thing that we'll improve the format and delivery of the Stopping Violence programs. You need to assess it, and that is provided for in this part of the bill. The assessment's a good idea. You need to tailor the services to more effective responses. I think that's good. The risk, Minister, and perhaps you'd like to comment on that, is that with the greater variety of programs you may well see some inconsistency in program delivery. I'd like to know from the Minister what she intends to do to ensure that while you can have diversity of programs, you also have a consistency in terms of the outcomes of those programs that are sought. The second thing that occurs in this section of the bill, Mr Chairman, as I've mentioned, is increasing the sentence for breach of the protection order. Now, the difficulty with doing that is that in many cases, increasing the penalty could make victims actually more hesitant to report breaches of the protection orders. Now, that again would have the perverse effect of achieving precisely the opposite of what you want to do in this section of the bill. The final thing I just want to comment on briefly is clause 35 of the bill, which changes the definition, adding to psychological abuse, financial or economic abuse. And the sort of thing that I guess we're trying to get at in this part of the bill is where one partner denies or limits access to financial resources or prevents or restricts employment opportunities for the other party. And I think it is important that those things are taken into account as reflective of the sort of psychological abuse that can happen in a relationship, and that part of the bill is helpful. So the detail, in summary, Mr Chairman, of Part 2 is that the detail is actually quite good. I think it's responsive to a particular need, and we're not opposing that part of the bill. But if you look at the wider impact of the bill, because of the denial of access of people to proper justice procedures to resolve family disputes, will be, as the Expert Advisory Committee said, to probably increase the risk of violence, not reduce it.
I call Chris Farfoy.
Thank you very much, Mr Chair. Just